Can you hear me?
Yes, Your Honor.
On the record, in the matter of the people of the state of Michigan versus DeAndre Ware, 24-02477 and 23-03024. Council appearance, please.
Assistant Public Defender John Lee appearing on behalf of DeAndre Ware.
Screen is looking like this. Let's see. Okay, you're Mr. DeAndre Ware?
Hello.
Okay, Mr. Ware, I do have a felony complaint that I'm going to arraign you on. The allegations are that on or about July 23rd, 2024, at the area of 4170 Windward Drive in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of assault with intent to do great bodily harm less than murder or by strangulation. The allegations are that you did make an assault upon a Sierra Vega with the intent to do great bodily harm less than the crime of murder, and that this was contrary to Michigan Compiled Law 750.84. Count 1 is a felony. The maximum penalty is 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MTL 750.506A if the assault was committed in a place of confinement. Count 2, domestic violence, alleges that you did make an assault or assault and a battery upon a Sierra Vega, an individual with whom you had a child in common or an individual with whom you had a dating relationship, and that this was contrary to Michigan Compiled Law 750.812. That's a misdemeanor with the maximum penalty of 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 3, assault or assault and battery. It alleges that you did make an assault or assault and battery upon a person by the name of Beautiful DeLeon, contrary to MCL 750.811. It's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charges read in the maximum penalty, sir?
Amen.
You have the right to be represented by counsel. Mr. Lee from the Office of the Public Defender is representing you today for the purposes of your arraignment only. You have the right to have an attorney represent you at each court appearance, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. Do you understand your right to counsel?
Yes, ma'am.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. Plead not guilty or stand mute. If you stand mute, the matter will continue all the way to a jury trial. You have the right in this matter to a preliminary examination, and you have the right to have it within 21 days of today's date. Today's date being the date that you're being arraigned. At the time of the examination, you have the right to require the prosecution establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with these crimes. You understand that?
Yes.
The timeline of 21 days that's set by statute, and it can only be moved if you waive the 21 days or if the court finds good cause to go beyond the 21 days, okay?
Yes, ma'am.
Okay, you have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to proceed to trial, and you have the right to a jury trial. At the time of trial, You have the right to see, hear, or question in court, in person, any of the witnesses that are called to testify against you. You have the right to subpoena witnesses to testify for yourself, or on your own behalf, or to present evidence that you believe show a defense to these charges. You also have the right to remain silent and not have silence at your trial be used against you, but you can waive your silence and testify at trial if you'd like. Do you have any questions about any of those rights?
Oh, ma'am.
You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
It's going to enter a plea of not guilty on your behalf. You're currently scheduled for probable cause conference before Judge Tony Flores. It's going to be October 10th, 2024 at 8:30 in the morning. You have a preliminary examination before Judge Flores, October 17th, 2024 at 8:30 in the morning, and you should have received a notice to appear for those dates and times. Did you get those?
Yes, I did.
Okay. You can appear via Zoom for the probable cause conference. However, you must appear in person for any preliminary examination, okay?
Okay, understood.
Yeah. Are you currently employed?
Yes, ma'am.
Where?
For Trim Pros, property management.
You said it was called what again?
Trim Pros Property Management is a company I started myself in 2019.
What's your home address?
4170 Windward.
That's not the address of the alleged victim, is it?
No, that's my home.
The alleged victim does not live there?
Oh,
What's your phone number?
517-719-1222.
Are you on probation or on parole?
No, ma'am.
Have you ever missed court in the past?
I have just recently for this other charge, the driving while license suspended, because I didn't think I had to appear because my license is valid. So I definitely had missed court. I think it was a few weeks ago.
Okay, you're talking about file number 23-03024. You missed court more than once. It wasn't just recently, sir. I see 3 failure to appears in this file.
I'm sorry. I wasn't sure of that. I wasn't sure of that at all.
You wasn't sure that you missed court in February 2024 and that you missed court again in February 2024 and then again in August of 2024.
But is it for the same charge?
Same exact charge.
Oh, I just wasn't aware that I had. I'm sorry, I wasn't aware that I had court dates in February. I just know. Sorry.
Okay, let's see. February 6th, you told the magistrate you thought it was a ticket. So for whatever reason,
Yes.
you didn't appear. Your matter
Yes.
was reset Your matter was then again reset, because you missed the first time, November 2023. Your matter was
Okay.
again reset to February 26, 2024, after you saw the magistrate on February 6, 2024, and she advised you that you missed your court date so that she would reset the court date. She reset the court date to February 26, so only 3 weeks later, and then you still didn't show up.
I thought, because I had to pay my fines, and I came down here and paid my fine. I wasn't aware of the court date.
You didn't pay, you were aware because the magistrate told you when you were arraigned on the bench warrant on February 6th. So you failed to appear on February 26th. So what happened was you were rearraigned again on this same driving while license is suspended. You were arraigned again on July 30th.
Right.
And the pretrial was again reset to August 2nd. You were given a notice to appear. Both times when you were arraigned on the warrant, you were given a notice to appear. So to tell me that you didn't know you had a court date would be really ridiculous, because you were given a notice. Don't open your mouth to talk over me. You were given a notice to appear, and then you still didn't appear on August 2nd. So you were properly advised, but there's something going on with the connector in your brain that lets you believe that you cannot come to court even though you're told to come to court. And yet you still stand before me and tell me you didn't know you were supposed to be here. I don't know how else we can let you know. If we tell you to be in court, we tell you the date, we give you the date. What else are we supposed to do to remind you or tell you that you're supposed to be here? I don't get it.
That wasn't, I guess it was the wrong choice of words. It was really because I thought that when I went and got my license, when I paid the fine for my license, that the case was resolved. I didn't know that I still had to get approval. When I came up here on the 6-4 and I paid to get my license reinstated. I had 2 tickets and I had paid them, so I didn't know that the case was still ongoing. That was completely my mistake.
Who told you that the case was dismissed if you paid your tickets?
I know the lawyer, when I first talked to the first
that was your understanding from your lawyer?
From the public defender, they said if I was to go get my license, I shouldn't have anything to worry about. And that's what was the thing. That was what I didn't know, if my license was reinstated, that I still had to come to court.
Yeah, I get it. And I can understand why they would say that, because that is accurate. If you get a driving while license suspended, if you go and get your license unsuspended, you shouldn't have anything to worry about. That's not telling you you don't have to come to court. You had a court date, you were supposed to appear until they tell you your case is dismissed. This is information you need to take and put in your back pocket so this doesn't happen again. Until someone tells you that your case is dismissed, you appear to court. You understand that?
Yes, ma'am, that was my mistake.
Yeah, well, you made it 3 times. Okay. Counsel, you can address bond.
Thank you, Your Honor. Mr. Ware has expressed to me that he does intend to defend himself vigorously in this case. He does live here in the area. He's lived in Lansing his whole life. And if he makes this a priority, I am sure that he will be here. I understand the court's concerns and leave it to the court's discretion. Thank you.
Okay, review his prior criminal history. There is a history of violence noted on his criminal history. This complaint as charged alleges 3 separate counts of violent actions, 1 being a felony. And then I have clear information here that evidences failure to appear in court. So personal recognizance bond will not be granted. I will, however, grant a 10% bond. Bond is set in the amount of 10%. You need to report to all of your court dates. You've received a notice to appear on the felony matter. The driving while license is suspended is going to be reset October 28th at 9:30 before Judge Flores. You should have received a notice to appear before Judge Flores on that date. Is that correct?
Yes, ma'am, I have it.
It looks like you previously posted a $250 cash bond on the driving while license is suspended. That was forfeited when you failed to appear. Bond in that matter is set at $300 cash or surety. While out on bond, you have the following conditions, and I'm addressing the felony file now about the conditions. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol, drugs, or marijuana unless you have a valid prescription. You're not to possess a firearm, ammunition, or dangerous weapon. You are not to have contact directly or indirectly with the alleged victim in this matter, Sierra Vega. Do you understand that?
Yes, ma'am.
You're not to be within 1,500 feet of wherever Miss Vega lives. That would include where she works, goes to school, or does business. You understand that?
Yes, ma'am.
So hypothesizing, if you pull into the drive-through and you find out she's working there, you would leave because you can't be within 1,500 feet of wherever she's working. Do you understand that?
Yes, ma'am.
You need to report to pretrial services within 48 hours of release from custody. I'm also going to put a no contact order in place for the protection of the alleged victim in count 3, a beautiful DeLeon. So you're not to be within 1,500 feet of beautiful DeLeon or wherever beautiful DeLeon works, goes to school, or resides or does business. Do you have any questions, sir, about your bond conditions?
No, ma'am.
Your next 2 court dates. I asked you a question.
Excuse you were asking, did I have any questions about those next 2 court dates?
No, I said, what are your next 2 court dates?
Oh, the 10th and the 17th at 8:30, both of them.
Before which judge?
Judge Flores.
Okay. Any questions about whether or not you need to appear in court?
Oh, you explained that I need, that I could do the probable cause on Zoom and I need to be there in person for the prelim.
That's correct. And your driving while license is suspended, you can appear via Zoom for that one as well, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir.
All right, thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Alysa St, file number 24-02549, counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Alysa St.
Are you Alysa St?
Yes, hello.
Hello. Okay, Ms. Stitt, I do have a felony complaint here. The allegations that I'm gonna arraign you on state that on or about April 27, 2024, at 462 East Edgewood Boulevard, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act in count one of stolen property, receiving and concealing a motor vehicle. The allegations are that you did buy, receive, possess, conceal, or aid in the concealment of a Toyota automobile, a stolen motor vehicle, knowing or having reason to know or reason to believe that the motor vehicle was stolen, embezzled, or converted, and that this was contrary to Michigan Compile Law 750.5357. It's a felony. The maximum penalty is 5 years and or $10,000 or 3 times the value of the motor vehicle, whichever is greater. To impose the fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. Do you understand the charge read in the maximum penalty, ma'am?
Yes.
You have the right to be represented by counsel. Mr. Lee is going to represent you today for the purpose of your arraignment only, but you do have the right to have an attorney represent you at all of your court appearances. You have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can have an attorney appointed at the expense of the public to represent you. Do you understand that?
Yes.
You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, this matter will continue all the way through to a jury trial. You have the right to a preliminary examination in this matter because you're being charged with a felony. You have the right to have that examination within 21 days of the date that you're being arraigned, so that's today's date, unless you waive the timeline, or unless the court finds good cause to go beyond the 21 days. Do you have any questions so far?
No, ma'am.
You have the right to require the prosecution establish sufficient probable cause that a crime was committed and sufficient probable cause to charge you with that crime at the time of your preliminary examination. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to proceed all the way to jury trial and require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at your trial. They cannot use the silence against you. You can waive your silence and testify at your trial if you like. You can subpoena witnesses to testify on your behalf or present evidence that you believe show a defense to the charge being brought against you.
Okay.
Do you have any questions about your rights so far?
No.
Is she requesting court-appointed counsel?
Yes, she is, Your Honor.
The court will enter a plea of not guilty on your behalf. You're currently scheduled for probable cause conference before me, Judge Kristen Simmons. It's going to be Friday, October 11th at 9 o'clock in the morning. You have a preliminary examination before me, Friday, October 18th at 9 o'clock in the morning. Did you get your notice to appear for those dates and times?
Yes, I did.
Are you currently on probation or on parole?
No.
Are you employed?
No.
Where do you live?
With my mom, 1685 Stillman Road in Mason, Michigan.
Spell the street.
You said what?
Spell the street.
Stillman Road.
Okay, what's your phone number?
517-499-5820.
You're currently on bond on another matter?
Yes.
Currently on bond on more than one matter.
Yes, I
You
believe.
got a bond in Fourth Circuit Court and a matter in Fourth Circuit and 56th Circuit?
I'm not sure, ma'am.
Okay, but you are sure that you have two matters that are pending?
Yes.
Counsel, you can address bond.
Thank you, Your Honor. Ms. Steed reports that she had a domestic violence conviction in 2019 and currently has at least one felony pending for resisting and obstructing. There is a retail fraud pending as well. I'm not sure what degree, if it's at the circuit court, could be first degree. She has lived here in the Lansing area her whole life and continues to reside here, intends to participate in these proceedings. Thank you, Your Honor.
Thank you. Yeah, she has police officer assault, resisting, obstructing felony pending in the Fourth Circuit Court that was recently bound over. And then it looks like she also has a felony controlled substance and another police officer resisting, obstructing that's bound over at the 56th Circuit Court.
Yes.
Therefore, personal recognizance bond will not be appropriate because you are currently out on two separate bonds when allegedly having picked up, or actually, what was the date of this alleged? Actually, I think these were alleged before she was charged with these. Okay, and this is, I think this case, date of incident actually predates the ones that are pending. So I will grant her a personal recognizance bond. Bond is set in the amount of $2,500 personal recognizance. You need to report to all of your court dates. You understand that, ma'am?
Yes, I do.
Okay, you got your notice to appear before me. You're going to be appearing before me on the 11th and on the 18th.
At 9 in the morning.
Exactly. While out on bond, you're not to use, purchase, or possess drugs, alcohol, or marijuana unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to engage in assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind, and you must report to Ingham County Pretrial Services within 48 hours of your release. Do you understand that?
Yes, ma'am.
You have any questions about your bond conditions?
Did it say there was a hold in another county or anything, or does it not tell you that?
It doesn't tell me that you have a hold. It does tell me that you've been bound over. I don't know whether or not you have a hold in one of, the date seemed relatively recently. It looks like one case was just last week that you were bound over on, so I don't know if you have a hold. Any additional matters for the record?
Nothing further. Thank you, Your Honor.
All right, you're all set, ma'am. On the record in the matter of the people of the state of Michigan versus Michelle Delaney, 24-01797. Here's for the record.
Assistant Public Defender John Lee appearing on behalf of Michelle Delaney.
Are you Michelle Delaney?
Yes, Your Honor.
Okay. I do have a I'm sorry. I have a felony, excuse me, complaint that alleges that on or about February 3rd, 2023, that you did allegedly at the area of Martin Luther King and Kavanaugh, City of Lansing, Ingham County, State of Michigan, commit the act in count 1, a police officer resisting, obstructing, or assaulting. The allegations are that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Bridget Boyson and or Officer Rebecca Hare and or Officer David Dallin, officers of the Lansing Police Department, that the defendant knew or had reason to know were performing their duties contrary to MCL 750.81 D1. it's a felony. Maximum penalty is 2 years and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 2, motor vehicle operation without security, alleges that you did, being the owner of a maroon sedan, a motor vehicle with respect to which security is required by MCL 500.3101, 3102, and 3103, did operate said vehicle upon Martin Luther King Boulevard, a public highway in the state of Michigan, without having in full force and effect security compliant with the above cited statutes. That's a misdemeanor. Maximum penalty, not more than 1 year and or not less than $200 nor more than $500. Count 3, operating while intoxicated, alleges that you did operate a vehicle upon a highway at Martin Luther King Boulevard while under the influence of a controlled substance. Notice, this offense resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor, maximum penalty 93 days and or $100 to $500 in fines and or 360 hours in community service, rehabilitative programs, vehicle immobilization mandatory with a prior and cost of prosecution reimbursement to the government for emergency response and expense for prosecuting the defendant. There is a count 4, alcohol open container in a vehicle, alleging that you did transport or possess an alcoholic liquor in a container that was open, uncapped, or upon which the seal was broken within the passenger area of the vehicle upon a highway in this state, contrary to MCL 257.624A. That's a misdemeanor. Maximum penalty 90 days and or $100 in fines, and community service and substance abuse screening can be ordered. Count 5, operating while license is suspended, revoked, or denied, alleges that you did operate a motor vehicle upon Martin Luther King, a highway, while your operator's license was suspended or revoked as prohibited by Michigan compiled law 257.9041, contrary to MCL 257.9043A. That's a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines and vehicle immobilization. There is an habitual offender, 4th offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about May 16, 2022. She was convicted of the offense of possession of methamphetamine in violation of MCL 333.74032BI in the 29th Circuit Court for Clinton County, State of Michigan. And that on or about October 24th, 2019. She was convicted of the offense of uttering and publishing in violation of MCL 750.249 in the 56th Circuit Court for Eaton County, State of Michigan. And that on or about May 26, 2016. She was convicted of the offense of receiving and concealing stolen property, motor vehicle in violation of MCL 750.5357 in the 44th Circuit Court for Livingston County, State of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.12 that would enhance the penalty to life if primary offense has a penalty of 5 years or more, or 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand each charge read there as well as the habitual offender notice?
Yes, thank you, Your Honor.
No problem. Okay, you have the right to be represented by counsel. Mr. Lee will represent you today while you're being arraigned. You have the right to have an attorney represent you if you're questioned by law enforcement, and you have to have a right to have an attorney represent you at all of your court appearances. If you can't afford to hire an attorney, one can be appointed at the expense of the public. You understand your right to counsel?
Yes, Your Honor.
Is she requesting court-appointed counsel?
No, Your Honor, she has independent counsel.
Do you know who you're going to retain?
Yeah, we're working on that, Your Honor, as I'm on bond right now from Clinton County.
Okay, what is the attorney's name that you plan to attend?
I'm sorry, what?
What's the attorney's name that you plan to retain?
Matthew Samuels.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to a jury trial. You have the right to a preliminary examination within 21 days of today's date unless you waive that timeline or the court finds good cause to go beyond the 21 days. At the time of your exam, you have the right to require the prosecution establish that they have sufficient probable cause that the crime was committed, and then probable cause sufficient to charge you with the crime. If this matter proceeds beyond the preliminary examination, you have the right again to have the prosecution put forth evidence at a jury trial to prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have that silence be used against you. You have the right to see, hear, or question any witness that the prosecution calls to testify against you at trial. You can call your own witnesses or present evidence that you believe show defense to the charges being brought against you, and you can waive your silence at trial and testify on your own behalf. Do you have any questions about those rights?
No, thank you, Your Honor.
Okay, you have the right also to be considered for pretrial release from custody. We'll address your bond in just a moment. The court will enter a plea of not guilty on your behalf. Currently scheduled for a probable cause conference before me, Judge Kristen Simmons, October 11th at 9 a.m. You have a preliminary examination before me on Thursday, October 17th at 9 a.m. Did you get a notice to appear?
I have it now, Your Honor.
That's what they be ready to do. It says the 17th. Oh, this way added up. Yeah. To the 18th? Okay. Yeah, that just struck me as odd because I shouldn't be doing exams on the 17th. So your date needs to be moved to the 18th for your exam. So your preliminary examination is going to be Friday, October 18th. At what time? At 9 o'clock in the morning, and we can get you a new notice, okay?
Thank you, Your Honor.
No problem. Are you currently employed?
No, Your Honor.
You said no?
No.
Okay. How do you support yourself?
I'm just saying,
Where do you live?
62 Nettie Avenue, Lansing, Michigan, 48906.
What's your phone number?
517-677-9746.
Are you currently on probation or on parole?
Nope, just out on bond.
You're on bond where?
Denton County.
Lee County Circuit Court?
It will be bound over to circuit here on the 10th, I believe.
Address bond, counsel.
Thank you, Your Honor. Ms. Delaney reports several contacts with the criminal justice system over the years, including a DV and larceny in 2007, retail fraud and fleeing and looting in 2009, and the felonies enumerated by Your Honor, as well as a couple of other offenses along the way. She reports that she has always participated and always appears. She's lived here in the Lansing area her whole life and intends to participate in these matters as well. Thank you, Your Honor.
The age of this case, I believe, predates the current case that she's on bond on, because again, the allegations of this is that this occurred back in February of 2023. So I'll grant a personal recognizance bond. Bond is set at 2,000 personal recognizance. You need to report to all of your court dates. You can appear before me by Zoom for your probable cause conference, so long as you have video capabilities with a stable connection and you're upright and in a position prepared to proceed with court. Otherwise, you must appear in person. And you have to appear in person for your exam, which is now scheduled for October 18th at 9 a.m., okay?
Thank you so much, Your Honor.
Okay, any additional matters for the, well, actually, let me give her some more bond condition. You're not to use, purchase, or possess alcohol or drugs while out on bond. You're not to engage in any threatening or assaultive behavior. You're not to travel outside the state. You're not to possess a firearm or any other dangerous weapon. And I'm gonna order that she participates in your analysis testing 1 time per week.
Easy.
Report to pretrial services within 48 hours. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. Do you have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record?
Nothing further. Thank you, Your Honor.
You're all set.
Your Honor, have a good one.
Thank you. On the record, in the matter of the people of the state of Michigan versus Danielle Brown, 24-02974. Counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Danielle Brown.
Okay, Mrs. Brown, I do have a misdemeanor complaint that you need to be arraigned on, alleging that you did on or about October 1st, 2024 at the area of 1205 Pierce Road, City of Lansing, Ingham County, State of Michigan, commit the act of assault or assault and battery. The allegations are that you made an assault or assault and battery upon the following person, that being a Pamela Eaton Champion, contrary to MCL 750.811. Count 1 is a misdemeanor with a maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty?
Yes, ma'am.
You have the right to counsel. Mr. Lee's going to represent you today for your arraignment. You have the right to have an attorney represent you if you're questioned by law enforcement. You have the right to have an attorney represent you at all of your future court dates. If you can't afford to hire an attorney, you can ask to have one appointed at the expense of the public. Do you have any questions about your right to counsel?
No, ma'am.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter is going to continue all the way to your jury trial. You have the right to a jury trial, and you enjoy the presumption of innocence. So that means you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at trial and not have silence be used against you, or you can waive the silence and testify if you like. You have the right to subpoena witnesses on your behalf that will testify and present evidence that you believe show a defense to this charge. And you also have the right to see, hear, or question any other witnesses in court that the prosecution calls to testify against you. You're currently scheduled to be before Judge Cynthia Ward Tuesday, October 22nd at 1:30 for a pre-trial conference. You can appear via Zoom. Did you get your notice to appear in the Zoom instructions?
Yes, ma'am.
Do you have any questions about your rights so far?
Oh, ma'am.
You have the right to be considered for pretrial release from the jail. We'll discuss your bond in a moment. Is she requesting court-appointed counsel?
Yes, she is, Your Honor.
Court will enter a plea of not guilty on your behalf. Are you employed?
Yes, ma'am. I run a business out of my home. And I'm in school full time.
You run what kind of business out of your home?
I'm in culinary school, so I feed people. So I cook my food. So basically I do catering, but I cook it all at home and then people can buy the food from me from my house.
Is there a name of this business?
Sardines.
What's your home address?
1101 Climax Street, Lansing, Michigan, 48912.
What's your phone number?
517-410-3040.
You currently on probation or on parole?
Yeah.
Do you have any other court dates pending right now?
Oh, ma'am.
How many times have you missed court in the past?
Never.
Counsel, you can address bond.
Thank you, Your Honor. Client reports some contact previously with the criminal justice system, a retail fraud in 2008 and embezzlement in 2009. Had some recent contact in 2022 where she pled guilty to 2 counts of R&O. But she has appeared and intends to appear in this matter, has lived in Lansing all her life, and doesn't present as a flight risk. Thank you, Your Honor.
Bond is set in the amount of 500 personal recognizance. While on bond, you need to make sure you appear to all of your court dates, okay, ma'am?
Yes, ma'am.
You need to make sure that you don't engage in any assaultive or threatening behavior. You understand that?
Yes, I will.
You're not to be within 1,500 feet of wherever Pamela Eaton Champion is. That's where she works, it's where she lives, it's where she goes to school, where she food shops, dry cleans, works out. You're not to be within 1,500 feet of that, you understand?
Yes, ma'am.
Are you not to have contact directly or indirectly with Pamela Eaton Champion? Do you understand that?
Yes, ma'am.
Okay. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. Additional matters for the record, counsel.
Nothing further. Thank you, Your Honor.
You're all set, ma'am.
Thank you. Have a good day.
Thank you. On the record, in the matter of the people of the state of Michigan versus Justine Campo, 21-03293. Maybe we're not ready on that one. Should I call that one later?
Oh, I think that's not too bad.
No. Campo? To,
Were you taking a nap?
Yeah.
You almost missed your turn. I mean, that would be devastating because you might have to wait till tomorrow. Okay, I have here file number 21-03293, council appearance.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Justine Campo.
Okay, Ms. Campo has a pending breaking and entering illegal entry that's pending before Judge Ward. And she can't seem to get to court. Maybe she's sleeping through her alarm. Mr. Lee, do we know what happened?
She reported to me, Your Honor, that there was some confusion and she was not aware that she was supposed to be in court that day.
What was the confusion, ma'am?
I thought that court date was this coming up court date that I have.
What coming court date that you have?
It's on the 11th or the 13th, I believe.
You have another matter pending? Do you have another matter pending?
Yes, I have a few.
In which court?
Am County, I believe.
Not this court, though, because we don't see you.
Oh,
However, that excuse is not quite gonna cut it. December 20th, 2021, defendant failed to appear for arraignment. March 13th, 2023, defendant failed to appear for court. Defendant says, I wasn't aware of the court date. Defendant shows up in October 13th for the second bench warrant. Says, I don't recall. Defendant failed to appear October 30th, 2023. Defendant failed to appear December 11th, 2023. Defendant failed to appear July 13th, 2024. Defendant failed to appear September 10th, 2024. You can address bond, Mr. Lee.
Thank you, Your Honor. She does have one other matter pending, just for the record, but it's in the circuit court and she's scheduled for sentencing according to our notes on October 4th, 2024. We understand the court's concerns and appreciate that the court will set bond accordingly.
Yeah, she can't keep up with her court dates, and the record that I have here indicates she's not employed, so that there's no excuse why she can't get to court on time. I don't even understand why she's tired, because she's not employed, so that means she should have plenty of rest. Nonetheless, bond is set at 5,010%. All of the other bond conditions will continue. You're gonna appear before Judge Ward October 22nd at 9:30. Do you have any questions?
no,
You're all set. On the record in the matter of the people of the state of Michigan versus L.C. Wilson Jr., 24-02976FY and 13-02793. Council appearance.
Assistant Public Defender John Lee appearing on behalf of L.C. Wilson Jr.
Okay, you're L.C. Wilson Jr.?
Yes, ma'am.
Okay, I do have a complaint here. It is a felony complaint that alleges that on or about October 1st, 2024, at 3200 South Washington, apartment 208, that you allegedly, contrary to law, committed the act in count 1 of assault with the intent to do great bodily harm less than murder or by strangulation. It alleges that you did make an assault upon a Tanya Nichols with the intent to do great bodily harm less than the crime of murder or by strangulation or suffocation, contrary to MCL 750.84. That's a felony with the maximum penalty of 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 domestic violence alleging that you did make an assault or assault and battery upon a Tanya Nichols An individual with whom you had a dating relationship contrary to MCL 750.812. Misdemeanor, maximum penalty 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, a third offense notice. Let's take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.813 on or about August 3rd, 2004, and by violating MCL 750.813 on or about July 9th, 2004, and by violating Michigan Compiled Law 750.8182 on or about August 15th, 1997, and therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.815. So that would enhance the count two to a felony. Maximum penalty 5 years in prison and or $5,000 in fines. The consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge of the maximum penalty and the third offense notice attached to the domestic violence charge. You have the right to be represented by an attorney, Mr. Lee. Mr. Lee is representing you today for the purposes of your arraignment. You have the right to have an attorney represent you at all of your court appearances, and the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can ask to have one appointed at the expense of the public. And if you're indigent, you can be granted one. You understand that, sir?
Yes, ma'am.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
The court will enter a plea of not guilty on your behalf. You have the right in this matter to plead guilty, plead not guilty, or stand mute. If you stand mute, though, the matter will continue all the way to a jury trial. You have the right to the presumption of innocence in this matter. You're innocent until proven guilty. You have the right to proceed to a preliminary examination within 21 days of today's date. The purpose of the preliminary examination is for you to require the prosecution to establish that they have sufficient evidence that these felonies were committed and sufficient evidence to charge you with these felonies. You have the right to have that within 21 days unless you waive the timeline or the court waives the timeline, okay?
Yes, ma'am.
You have the right to remain silent at any jury trial and not have silence be used against you. You have the right to confront and cross-examine in court any of the witnesses called to testify against you. You have the right to call your own witnesses to testify and present evidence at trial that you think show defenses to these charges. And you can waive your silence at trial and testify if you'd like. Do you have any questions about those rights?
No, ma'am.
You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Are you currently employed?
Oh, ma'am, I have a SSI.
What's your home address?
3200 South Washington, the Capital City Apartments, apartment 208.
What's your phone number?
517-580-1536.
Are you on probation or on parole?
Oh, ma'am.
Does Tanya Nichols live at this address on South Washington?
No, ma'am.
Okay, you have a 2013 no fishing license case. That you failed to appear for the arraignment back on July 5th, 2013. That matter is going to be reset for October 28th at 9 o'clock in the morning. And it's going to be before Judge Flores, okay? The allegation on this is that on or about June 23rd, 2013, at approximately 3:50 p.m., apparently this was a Sunday, that you were upon the area near Grand River, City of Lansing, Ingham County, State of Michigan, and that you failed to produce a fishing license. We'll enter a plea of not guilty on your behalf for that, and you'll continue to your next court date on that. 11 years later. Let's see. You have a probable cause conference before Judge Tony Flores on the felony matter, October 10th at 8:30 in the morning. You have a preliminary examination before Judge Flores on October 17th at 8:30 in the morning. Did you get notice to appear for those dates?
Yes, ma'am, I have.
Okay. Do you have any other court dates pending?
No, ma'am.
Okay, counsel, you can address bond.
Thank you, Your Honor. Your Honor has already noted the criminal history. We would just ask the court to consider that Mr. Wilson has lived in the Lansing, Michigan area his whole life and intends to participate in these proceedings. Thank you.
Well, I noted what was indicated in the habitual offender notice. That was not a complete listing of all of the assaultive convictions on Mr. Wilson's history. Or all of the times that he's been charged with crimes of assault or domestic assault. That's the nature of his criminal history, which spans at this point well over 30 years. I do also have a bond recommendation from the Ingham County Prosecutor's Office. They express a concern to the protection of the public. Said the crimes charged involve violence towards another person, a person that's in an intimate partner relationship with the defendant, and that there are some risk factors that indicates that the defendant is an habitual domestic batterer with a documented history of interfering or attempting to interfere with his victims reporting to the police. There is a request for a money bond to be issued and a no contact order put in place. You can address any further bond issues with that, Mr. Lee.
Thank you, Your Honor. And we certainly do appreciate that. There is an extensive history that does include violence And that does run through the criminal history. We understand that. We appreciate that. We would always encourage the court to use any sort of bond conditions up to and including tether to maintain the no contact and the protection of the witness. We would ask the court to consider, if it would, a 10% bond that might allow Mr. Wilson to be out while the matter is pending. Thank you, Your Honor.
Bond is set in the amount of 5,000, 10%. While out on bond, he will wear GPS tether with victim notification. He's not to be within 1,500 feet of wherever the victim is. You understand that?
Yes, ma'am.
You're not to have contact directly or indirectly with the victim. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind. You have to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You need to report to pretrial services within 48 hours of release. You have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir.
Thank you.
Like I said, the bond on the fishing is 100 personal recognizance.
Thank you.
Who's that?
I'm his sister, and I was a bakery and medicine.
Oh, you can take that down to the jail.
He has mental issues.
You can go down to the, she can take that down to the 3rd floor.
I thank you. Is there any
Yolanda,
way we can
She
get
can take it to the 3rd floor.
not drug, but alcohol treatment?
Apparently, there's a bag of medication that they're gonna bring to the jail. Okay, let's see. On the record in the matter of the people of the state of Michigan versus Randy Timmons. 24-02970, and then I have 21-01308, council appearance.
Assistant Public Defender on behalf of Randy Timmons. It should be noted, Your Honor, I have not had an opportunity to talk with Mr. Timmons prior to this hearing.
Oh, that's not good.
No.
Okay, let's see. Well, I have an assault and battery here. And then the other file. Okay, well, the assault and battery, let me arraign you on that. And then advise you of your right to counsel. So, Mr. Timmons, you have a misdemeanor complaint here. Alleging an assault or assault and battery having occurred on September 30th, 2024 at 3200 South Washington Ave. Looks like it was real busy in 3200 South Washington Ave.
Sorry, 21, 3200, you said?
3200 South Washington Ave is the address that's alleged on this complaint, okay, sir? The allegations are that you made an assault or assault and battery upon a Brenna Claver, contrary to MCL 750.811. That's a misdemeanor, sir. The maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand?
Yes.
All right. You have the right to counsel in this matter, and Mr. Lee has put his appearance on the record, although it's unclear why you did not have an opportunity to meet with him prior to the arraignment. But you have the right to have an attorney represent you at all of your court appearances, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have a public defender appointed to represent you. You understand that, sir?
Yes, ma'am.
Okay, do you think you might want to request the public defense to represent you, sir?
Yes, ma'am.
So the court's gonna enter a plea of not guilty on your behalf. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute, but of course, for this purpose, the court is going to enter a not guilty plea on your behalf. You have the right to proceed to a jury trial on this matter. You have the right to the presumption of innocence. So that means, sir, that you're innocent until proven guilty unless you waive that right and enter a guilty plea. You have the right to require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You understand that, sir?
Yes, ma'am.
You have the right to remain silent at trial and not have silence be used against you, or you can waive the silence and testify if you'd like. You have the right to confront in court and cross-examine, which means question, any of the witnesses that the prosecutor calls to testify against you at trial. You can subpoena witnesses to testify for yourself at trial or present evidence that you believe show a defense to the charges being brought against you. You also have the right to be considered for pretrial release from custody, and we'll adjust your bond in just a moment. But do you have any questions about those rights?
No.
You're currently scheduled to be before Judge Cynthia Ward, Tuesday, October 22nd at 1:30, and that's for a pretrial, okay?
Yes.
Are you employed, sir?
No, but I get social security income.
What's your home address?
3200 South Washington Avenue, apartment 138.
Okay. It's unclear to me, but based on this, I believe that the alleged victim lives at that same address. And if that is the case, sir, you're not going to be able to live.
For me,
within a
nobody lives
certain-
with, I live by myself.
Sir,
Yeah.
sir. Look, I told you
Yes,
you have the
ma'am.
right to remain silent. So I don't want you to say anything that could be used against you. That's first. Secondly, I don't want you to cut me off when I'm talking, okay? So I'm going to explain something. I did not say that someone lived in your unit with you. I recognize 3200 South Washington is an apartment building with multiple units. However, what I was stating was that you're not going to be allowed to be within a certain distance of the alleged victim, okay?
Yes, ma'am.
I've not yet set what that distance was, but I don't even have information as to where exactly the alleged victim or what unit that alleged victim would live. Nonetheless, you said you live at what unit?
38.
Unit 38. Is it 138?
Yes.
What's your phone number?
I don't have a phone.
Are you currently on probation or on parole?
I don't know.
You don't know if you're on probation or parole?
Think not.
Do you have any other Criminal matters pending?
No,
You said no?
yes, no, I don't.
Have you ever missed court in the past?
Ma'am.
I couldn't hear you.
No,
Oh, okay. I have here, however, 21-01308, which would indicate that you do have another matter pending and that you've missed court before. It looks like this is for an assault and battery for Judge Ward.
I appeared off for that. I already went all through that already. All through it, it's over with. Probation, everything's over with.
Your Honor, I do have some information from our files if the court is interested.
Oh, Judge Ward left some extensive notes here. Let's see here.
Jesus.
The defendant was supposed to be in residential treatment and he left early. He was supposed to serve 93 days Ingham County Jail, credit 18 days. It says defendant may be released to residential inpatient treatment and receive day-to-day credit. Balance of jail would be suspended upon successful completion of residential treatment. The indication or information provided by Community Mental Health was that on or about July 17th, 2023, Randy Timmons left the House of Commons against the staff advice on July 13th, 2023. Judge Ward issued a bench warrant. It's been in warrant status since then. Is that the information you had in your record?
Your records are more extensive than mine. Mine just indicated that probation was revoked and he was remanded to ICJ. So apparently there was the residential treatment agreement and that didn't go well.
Okay, okay. Let's see. I'll note here that he wants court-appointed counsel. We'll also obviously need for you to get with him to get some information so that he can have court-appointed counsel noted. And you wouldn't really be in a position to address bond, but to be honest, I have a concern about the bond only because I believe he lives in the same apartment address with the alleged victim. And the allegations was that this alleged victim came home from work late at night, and that the defendant was hiding or lurking and allegedly assaulted her. And this is information allegedly that could be viewed on surveillance camera. And so if they live in the same apartment, and then that's a concern. And I understand there's a presumption of innocence, but these allegations are concerning because this person was allegedly crouched between the dumpster holding something, allegedly waiting with a paint scraper or something sharp in attempted to attack the alleged victim. And now that's resulted in assault and battery charge. So if I can get confirmation that the addresses are the same building that is, I'm issuing a no contact order. He's not gonna be able to live in that building while she's there. So that's my concern.
Anyway. I'm being evicted on the 9th of this month anyway.
Okay.
Mr. Timmons, do you have anywhere else that you can stay that you have plans for?
No, but I can go to the VOA.
Okay.
Okay, bond in this matter will be set, and that's the assault and battery at 100 cash surety. There's a no contact order. You're not to be within 1,500 feet of wherever the victim lives, works, or goes to school. A victim by the name of Brenna Claver. Do you understand that?
Yes, neuro, so, you know.
I'm sorry, I couldn't hear you.
I said, I understand that, yes, but I never assaulted her though. She just got scared of me when I came in. the
Okay,
door.
don't say anything more, Mr. Timmons. Don't say
just-
anything more. No facts about the case, okay?
Yes, sir.
Thank you.
Your Honor, you said 100 cash surety.
Yes. Okay, not within 1,500 feet. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to engage in any assaultive or threatening behavior, and you need to make sure you appear for your court date before Judge Ward, Tuesday, October 22nd. Do you have any questions about that file?
No,
As to 21-01308, bond is denied. He'll be remanded to see Judge Ward. Any additional matters for the record?
what does that
Nothing
mean?
further. Thank you, Your Honor.
Okay, you're all set, sir.
You just gave me a bond, and what does that mean? You just gave me a bond for $50 or $100 and now you deny it?
No, you got two files, sir. Your new file is the assault and battery allegation. That one, the
Yeah.
bond is $100 cash surety. You have an older file that was before Judge Ward, and you were released to residential treatment after being sentenced to 93 days in the Ingham County Jail with credit for 17 days. The House of Commons has reported to the court that you left treatment shortly after being admitted there, and you did not complete your term of sentence ordered by the court. So you're being remanded to see the judge that sentenced you. Do you have any questions?
No, ma'am. No, thank you.
You're all set. Okay, on the record, in the matter of the people of the state of Michigan versus Spencer Drummond, I have 24-02975, 24-01583, and 24-02975 again, council appearance.
Assistant Public Defender John Lee appearing on behalf of Spencer Drummond.
He must be wrong. It should be. Excuse me.
Spencer Dumond, I'm sorry. Did I say Drummond?
Spencer Dumond is what I have here. And then
I
also the other
apologize.
file number was probably a typo on here, but there's three separate files. So 24-01583, 24-01582, and then 24-0922975. And it's Spencer Dumond. Mr. Dumond has two dog cases. One is a dog unlicensed. Let's see, the allegations on this citation is that on or about May 14, 2024 at 5:36 p.m. at the area of 1117 Lincoln Ave, at or near 1100 block of Lincoln Ave, that you allegedly committed the act of dog at large and an unlicensed dog in violation of Article 9, Section 1. And so both are misdemeanors with the maximum penalty of 93 days in jail and up to $500 in fines in both. Do you understand that?
Yes, ma'am.
Okay, then I have 24-02975. That's an aggravated domestic violence. The allegations are that you did assault or assault and batter on or about October 2nd, 2024 at 1117 Lincoln Ave, City of Lansing, Ingham County, State of Michigan, a Julia Dumond, who's an individual with whom you had a child in common and or your spouse without a weapon and did inflict a serious or aggravated injury upon her, but without intending to commit murder or to inflict great bodily harm less than murder, and that this was contrary to MCL 750.81A2. It's a misdemeanor. The maximum penalty is 1 year in jail and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge there and the maximum penalty?
Yes, ma'am.
Okay, in each of these matters, you have the right to be represented by counsel. Mr. Lee's going to represent you today for the purposes of your arraignment only. You have the right to have an attorney represent you at all of your court appearances. You have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire or retain your own counsel, you can make a request to have one appointed at the expense of the public. You have the right to proceed to trial in each of these matters, and you have the right to a jury trial. You have the right to be presumed innocent until proven guilty and require the prosecution prove each element of the charges being brought against you beyond a reasonable doubt. You can remain silent by right at your trial and not have silence be used against you. You have the right to subpoena witnesses to testify for you or present evidence that you believe show a defense to these charges. Or you can waive your silence at trial and testify on your own behalf, but you have the right to see, hear, and question any witness the prosecution intends to call. You also have the right to be considered for pretrial release from custody, and we'll address your bond in just a moment. Are you employed, sir?
Yes, ma'am.
Where?
Apex Home Solutions.
What's your home address?
1117 Lincoln Avenue, Lansing, Michigan.
Where are you gonna live during the pendency? Yep, where are you gonna live during the pendency of this matter? Because you won't be able to live there because that's where the victim lives.
I understand, ma'am. I actually regularly stay with my parents because me and my wife are in like talks of separation. So I'll be staying at my parents full time.
Where do they live?
2600 Sorority Lane, Holt, Michigan.
Spell that, please.
SORORITY.
Okay, so
And
where
then
are you
like-
living? In
Yep.
Holt?
Yes, ma'am.
What's your phone number?
517-316-6914.
Are you on probation or on parole?
Oh, ma'am.
Do you have any other court cases pending?
I do.
Where?
In 55th District Court.
For what?
It's an OWI, man.
Oh, so you're out on bond for 55th.
That is correct.
For the dog at large and the dog licensing matter, you have a pretrial conference before Judge Buchanan. Both are scheduled Monday, October 28th at 10 o'clock in the morning. For the aggravated domestic violence, you'll have a pretrial also before Judge Buchanan. That'll also be on October 28th at 10 o'clock in the morning. You should have received a notice to appear for all of those three files, okay?
Yes, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Dumont has had prior contact with the criminal justice system dating back to at least 2011, where there was a conviction for a malicious destruction of property. There was also a home invasion third degree in 2012. I show financial transaction device and receiving stolen property convictions in 2011 and 2014, a larceny conviction in 2016, another home invasion third in 2016, and an unlawful driving away in 2016. The defendant intends to participate in these hearings and has assured me that he will appear. He has lived here in the Lansing area, been a homeowner, that is to say, here in Lansing since 2020, originally from Holt, Michigan, Your Honor.
Okay, bond of the dog at large. It's gonna be $100 personal recognizance. Will be unlicensed, $100 personal recognizance. Report to court for all of those dates. Typically with a dog license and dog at large, the prosecution is seeking you to show conformance with the statute, that you either have the dog license, that you no longer own the dog because you surrendered it, and or that you secured the dog from getting out. And if you provide that evidence, they have been dismissing those cases, okay?
Okay.
As to the aggravated domestic violence, you're out on bond at this point, and there are allegations now of a assaultive or threatening action. I do have a bond recommendation from the Office of the Prosecutor here. It says here the defendant is on parole, probation, or has other criminal matters, and that this crime involves violence towards another person, and that the defendant has a history of violent behavior directed toward the victim, and a history of threatening and or harassing behavior toward the victim and witnesses, and that there's an intimate partner relationship. That the other factors of lethality that the prosecution would like the court to consider is that there's been threats to kill the victim or the victim's family, that there's a recent separation or divorce, some acute depression or unpredictable and violent mood swings have been noted in attempts to isolate the victim and prevent the victim from reporting, that the crime committed was in the presence allegedly of children. It says here that the victim is 4+ months pregnant with the defendant's child, and at the time of the assault, the defendant has previously physically assaulted the victim while she was holding their young child, posing extreme risk of harm to the child as well as to the victim, and that the same child was present at the time of this alleged assault. The people are requesting a money bail with conditional release under Michigan Court Rule 106D, including a no contact order and a GPS tether, and no unsupervised parenting time with the minor child. You can address bond counsel.
Thank you, Your Honor. That is to say, I cannot comment really on the specific history between Mr. Dumond and Mrs. Dumond. I don't show that there are any prior domestic violence convictions, but I don't know that there weren't any charges that were dismissed either. I don't have that information. I would say that Mr. Dumond certainly would respect any no contact orders, and the court probably could use other things like GPS tether and so forth to even further protect the complaining witness in the matter. And we understand that we would only ask for some type of a 10% bond, that he might have an opportunity to be free while this matter is pending.
I reviewed the prior criminal history. I do see a previous charge of domestic violence as well as a previous charge of child abuse in the 4th degree. Also, there were indications in the affidavit of probable cause that tend to be or establish where the prosecutor was going with their request. And obviously the prosecutor would have more information than both you and I at this stage as to underlying factors that could present a threat to the public safety and a threat to the victim in this particular case. The court is going to adopt the report in some extent, but in others will not. The bond in this matter will be set at 2,000 cash surety. There will be GPS tether with victim notification. You're not to be at the address of 1117 Lincoln Avenue. Do you understand that?
Yes, ma'am.
You're not to be within 1,500 feet of wherever Julia Dumond is. You're not to have contact directly or indirectly with Julia Dumond while this matter is pending. Do you understand that?
Yes, ma'am.
Do you have any questions about that?
About the tether, is that a cost associated with it?
Yes, there is a cost associated with it. However, depending on your financial situation, you may be able to apply for assistance to get that taken care of. And Mr. Lee would have further information about that, okay?
Okay.
Do you have any other questions?
No, thanks.
The prosecution did request for the court to, in addition to GPS tether, with exclusion zones, to issue a no unsupervised parenting time with the minor child. This is not the family court. We don't address parenting time. So the court is going to decline to address that. However, there is a no contact order. So you're still not to have contact directly or indirectly with Julia Dumond. If the family court decides that they want to intervene as it relates to the protection of the children, that's what they're supposed to do. And I'm inclined to believe, due to the nature of the charges, that CPS has probably been notified on this. Nonetheless, also, you're not to engage in any assaultive or threatening behavior while on bond, and you're not to possess a firearm, weapon, or ammunition of any kind. You're not to have drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. Do you have any questions about any of your bond conditions on any of these files?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, Mr. Dumond.
Thank you.
On the record in the matter of the people of the state of Michigan versus Gaston Mayberry, 24-01807. Well, that didn't take long. How are you, Mr. Mayberry?
Doing well, Your Honor. How are you?
Counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Gaston Alfonso Mayberry.
Mr. Mayberry, you were before me in August. You pled guilty to count 1, retail fraud, second degree. It's a maximum penalty of 1 year and/or $2,000 in fines. You were in custody until the 6th of September. I set your sentencing for September 27th. September 27th just passed. You did not appear.
They freed me on the 25th, and I got the days mixed up. I wasn't trying to like run off or escape or like I just got the days mixed up. I was going through a lot with my family, my ex-wife, my kids, trying to balance life, trying to get my life back on track. It's like I have a lot on my plate. I wasn't trying to be a flight risk or just run off. It's just I misplaced the dates. I have a lot on my plate, Your Honor. Like,
Where are you living, sir?
well, right now I'm considered homeless, so I have no address.
Where are you sleeping? Are you at a shelter, or is there any place where your mail is going?
Shelter on West Michigan, Jesus Saves.
You have a phone?
No, currently have no phone yet. like I said, it's very hard for me right now. I'm barely getting through.
Who's the new referral?
I don't think so, because it was done.
Oh, okay, sounds good. Okay, we're resetting your sentencing for October 17th at 9 o'clock in the morning. How are you gonna keep up with that date, sir?
I guess if you recommend a PR bond, I can get me a phone and set it on a planner or something so I won't forget.
Okay, what if you don't get your phone? How are you gonna keep up with your date?
I have a good memory, so I
You have a good
can.
memory? When did the good memory start? Did you just told me they had a lot going on and you mixed it up?
I mean, I do have a lot going, but I can make it this time to this court date. You just said the 17th, and I promise I will be there.
Okay, did you get a copy of the notice to appear?
Yes, I did, Your Honor.
Okay, where is it?
Right here.
Okay, so don't forget your notice to appear. You've already met with probation, so I don't need to get you back to before probation. I think your bond previously was at 5,000, 10%. That'll be reinstated. You're all set.
I didn't get the question.
I didn't ask a question, sir. You must have PR'd him because I didn't. I don't see where he had a PR bond. Unless I missed something. I reinstated your bond that you previously had. I never gave you a PR bond to begin with. I think the jail PR'd you on the 25th because you failed to post the bond. So you need to report back to court on the 17th. And they PR'd you probably because the capacity issues. 500 personal recognizance. I have to give you a PR bond because otherwise you'll be sitting there because you couldn't post the 5,000, 10%. So it's 500 personal recognizance. You need to report back to court, okay, sir?
Thank you, Your Honor. God bless you.
You're welcome. Same to you. Let's see, on the record in the matter of the people of the state of Michigan. Well, I think these are city of Lansing. People of the city of Lansing versus Wendell Aldridge, 21L2669-821-822, 24-02959, 24-02977. Appearances, please, counsel.
Assistant Public Defender John Lee appearing on behalf of Wendell Aldridge.
Okay, Mr. Aldridge, you have 4 separate files here today.
Yes, ma'am.
I'm gonna arraign you on the trespass. And I think there's a false information. Let's see here. I have a citation here that alleges that on or about October 2nd, 2024, at 9:14 in the morning at the area upon Truck Court at or near North Larch, City of Lansing, Ingham County, State of Michigan, that you did allegedly trespass on the property of another. It also says that the accused refused to provide email or phone number. That's a misdemeanor, maximum penalty 90 days and or $500 in fines. I have another citation that alleges that on or about September 25th, 2024, at approximately 11:04 p.m. at the area of Truck Court, at or near North Larch Street, City of Lansing, Ingham County, that you did allegedly furnish false information to the police when questioned. That's a misdemeanor, maximum penalty 90 days in jail and or $500 in fines. You have the right to be represented by an attorney at your court dates on those matters, and all your court appearances, and you also have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford an attorney, one can be appointed to represent you. You have the right to be presumed innocent until proven guilty, and require the city prove your guilt at trial by proving each element of the charges that are being brought against you beyond a reasonable doubt. You can remain silent at your trial and they can't use the silence against you, or you can waive your silence and testify if you'd like. You can present defenses at your trial or subpoena evidence, subpoena witnesses that would present evidence and testimony on your behalf. You also have the right to see, hear, or question any witness the city calls to trial and question them at your trial. You also have the right to be considered for pretrial release from custody, but we'll address your bond in a moment. Do you understand?
Yes, ma'am.
You're right, sir. Okay, is he requesting an attorney, Mr. Lee?
Yes, he is, Your Honor.
Okay, on both of your matters, you got a pretrial before me on Monday, October 21st at 10:30 in the morning, okay?
Yes, ma'am.
What's your address?
500 South Pine, apartment 508.
Phone number.
517-455-3187.
Are you employed?
No, ma'am, but I do little things for my mom, so they like I take care of her because she's bedridden. So I kind of like get paid by doing that.
Why didn't you come to court on August 12th?
August 12th? What matter is that, ma'am?
You have any other court dates pending, sir?
Yes. I'm on bond. I'm on bond right now, ma'am, and I go back to court on the 7th for a traffic ticket. That was
on the 7th?
Yes, ma'am.
Of October?
Yup. Yes.
Yep. Yes, that's for failure to display ops?
Yes. Yup.
Do you know why you go back to court on the 7th?
I don't really know, ma'am. I really don't know.
Because you didn't come on the 12th, so I issued a bench warrant.
Oh, yes, yes. Okay, yes. I'm sorry, ma'am. Yes, that's the reason why.
Yeah, so we had to reset it because you didn't come.
Yes.
And then you must have showed up to try to be arraigned. I think I saw your name pop through. Did you show up yesterday to try to get arraigned?
Yes.
Okay, so that's where you got the 7th date for. So I like what you did there. I like how you tried to act like you didn't miss court and then you just had a 7th date. But what you did was you did miss court. You were notified that you had a bench warrant. You showed up, you went to the counter. They emailed us, say, hey, is there any judge that can do an arraignment? But we were all busy. And if we're not available to do the arraignment within a certain time frame, they get you a date to appear. That's what's going on there. So you knew you had a warrant then, correct?
Yes. And I wanted to take care of the matter. I wanted to take care of it, so that's why I did it that way.
I'm glad, sir. I'm happy to hear that you wanted to do that because it's not your first bench warrant on that file. And we want that resolved, sir. We don't really want to continue to interact with you about this licensing thing from 2021. Yes. I promise you that, okay?
Yes. I thank you, ma'am.
And you have a no proof of insurance from 2021, and you owe us $258, and you've not paid anything on that. And if you don't pay it, you know what can happen?
I'll come back to jail.
You'll have to serve it in jail because you won't pay us the money, and we don't like to put people in jail because of money. But you give us no choice. When you don't show up to court, you get a default, a fine is assessed, and then you don't pay it, and then you don't pay it. So when are you gonna pay the $258?
I could put at least a few dollars on it in the next 2 weeks because I do get some money. What I do for my mom, I can at least put about 50 on it. if that's all right with you.
Okay, you're gonna pay $50 and you said 2 weeks?
Yes, ma'am.
And when are you gonna pay the next payment?
Well, then, you know, I gotta wait another month for the money that I do for my mother. So it'll be like a month later, and I probably will give
Okay.
100 then.
Okay, so 2 weeks from today's date, sir, is gonna be the 16th of October. So you're gonna pay $50 on the 16th of October and $50 on the 16th of each month, okay?
Okay, thank you, ma'am. Thank you.
And you already have your next court date for the failure to display ops. That was set. Well, it's now, they've moved it, I think, because that was an arraignment date for the 7th.
Yeah, no, it's the 21st.
Okay, so you, sir, let's be clear. You no longer have an October 7th date. The October
Okay.
7th date that you were giving was for you to come and be arraigned, but you're being arraigned on it now. So you don't have to
Okay.
come on the 7th. Your next court date on that failure to display ops is going to be October 21st. So all 3 of your files, you'll come back on October 21st, okay?
Okay, thank you.
You don't want to miss court because it'll really make your mom upset. You understand that?
I'm not gonna miss court, ma'am. I'm not gonna miss. I want to get all this stuff out because they missed me, and plus I want to get my license back. I had a pretty
Okay.
good record till I messed up.
Okay, well, you can work with the public defender to try to get your license restored because the city will give you a reduction and possibly even consider dismissing if you can get your license, but you gotta get your license. As to the other matters, the court entered a not guilty plea on both, the trespassing bond is 100 personal recognizance. And the false information is 200 personal recognizance.
Thank you, ma'am.
Be back in court on the 21st. Any additional matters for the record?
Nothing further. Thank you, Your Honor.
Thank you. You're all set, sir.
Thank you, ma'am. God bless you.
Same to you. That's all I have.
Thank you, Your Honor. It was a pleasure to see you again.
Same to you. You're over across the hall now, so we don't get to spend that much time with you anymore.
I know. I always peek in the window when I go by and see you guys working hard and stuff. I'll stop by for a visit sometime.
Sounds good. Have a good one.